Hello, I'm Will Inman, a partner with the law firm of Inman, Kaminow. Today I would like to provide you with a special report on the way COVID-19 can affect workers' compensation claims. Because of the COVID-19 pandemic, many people have been filing workers' compensation claims alleging that their COVID-19 virus is related to their employment and thus should be paid under the Workers' Compensation Act in Maryland or the District of Columbia. Please keep in mind this video only applies to employees who work in Maryland or the District of Columbia, and it does not apply to federal employees or DC government employees. To prove that your COVID-19 sickness is related to your job is very difficult to do. This is because it is hard to determine exactly where you contracted the COVID-19 virus. However, there are exceptions. I recently won a case for a client who did indeed contract COVID-19 at work, and her employer challenged the case, saying that she couldn't prove that she contracted COVID-19 at work. After we won the case, her employer was ordered to pay her over 1 year of back lost wages and hundreds of thousands of dollars of medical bills related to the case. Her COVID-19 virus was extremely bad, and she was off work for over a year and unfortunately continues to be off work to this day. In order to prove the case, we had to prove to a workers' compensation commissioner that at the time our client contracted COVID-19, that it was extremely unlikely that she contracted it outside of the employment. In this particular case, she was at work. They were not practicing social distancing. They were not wearing masks. And in her home life, she lived alone. Because of the COVID lockdown, she was not traveling anywhere, she wasn't going anywhere, hadn't been to a hospital, hadn't been to a medical facility, had not even been to a grocery store. So we needed to exclude as much as possible other types of exposures to COVID-19. But also, we needed to have a letter from one of her physicians stating that it was the doctor's opinion that she contracted COVID-19 at work. Fortunately, her doctor provided such a detailed letter, which we provided to the commission. Also, we had to show that it was more likely than not that her COVID exposure was done at work and not out in the general public. This was a combination of factors that we had to prove to the judge. We argued that there was clearly no other reasonable exposures that she had due to the fact that she had been isolating at home. We argued that the work environment led to a high probability of exposure to COVID, being that there was no social distancing and being that there was no mask requirement at the employer at this time. We argued that from a medical standpoint that a qualified medical expert, her personal physician, it was that doctor's opinion that the work exposure is where COVID was contracted. And we also looked at the big picture of the timing of when she got sick compared to when she was required to show up to work for an emergency meeting, which took place in a fairly small room with a lot of people in the room with no social distancing. And her symptomology came up within 2 weeks from that appointment. So it all lined up. This required a great deal of work and a great deal of investigation, obviously, and these cases can be very difficult to win, but not impossible. So if you feel you've contracted COVID-19 at work, please call us. We'll see if we can help. Thank you.